Good morning, is it Cimini?
Cimini.
Cimini.
May it please the Court, my name is Mark Cimini. We're here today to discuss the lack of jurisdiction of the Probate and Family Court in the matters of divorce, custody, and child support. There are several points I would like to make today, starting with there are two standing U.S. Supreme Court orders, which are in the pleadings, and one from the Federal First Circuit Court of Appeals, requiring that parents patriae and custody matters be done under common law jurisdiction. The next point, there have been significant changes in Massachusetts law that result in absurd shifts in burdens of proof. And normally a burden of proof is prove that you didn't harm the child, from the state having to initially prove you did harm the child. Here we have prove that you didn't abandon the child versus you're now in a disadvantaged class that we've created artificially called non-custodial parents. It did not exist under common law. I'm also claiming that there are Ninth Amendment violations, that custody under common law provided for no interference with the natural right to a fit parent to the custody of their children. None. That the best interest existed under common law, but only as once that right had been abdicated or forfeited.
Mr. Cimini, are you aware that in the usual course of proceedings, something like this has to be completed in the probate court, and then if you lose, you appeal to the appeals court at that point? You just don't jump over everything and try to come directly here?
I didn't jump, sir.
You did?
I went to appeals court, filed the paperwork, received the paperwork back with a handwritten note on one of the front covers that said, we have no common law jurisdiction, you need to take this to the Supreme Court. That's all I got back from the appeals court.
Okay.
So I did try the appeals court, and I thought...
The probate action is still pending.
No, the probate action is over.
It is?
Yeah.
Was it over at the time that you filed here?
Pardon?
Was it over at the time you filed here?
No, I did not, because this is questioning the jurisdiction. I'm subsequently going to, go and question the findings that the court had. And so this was questioning the jurisdiction. Judge Donnelly did not address the issues. He said he only had to deal with the statutory construction of the law, did not have to deal with the constitutional issues that I was raising. For instance, the best interest is a whole different context under common law than it is under equity. And his answer was, well, best interest goes way back into at least the 1800s in his findings. That's not the point. The point is, under common law, best interest was once you had abdicated or forfeited your right, best interest kicked in. You've now, in this context, in equity, raised it above natural rights, violating the Ninth Amendment. The common law did not provide for the court, even during divorce, any intrusions into the fit parent. Common law defined as a natural right based on the marriage contract. If you did not have a marriage contract, the woman had the natural right to the child, period. And Wright v. Wright said that explicitly. If you did have a marriage contract, the father did. And I have several cases in there of that. And I tried to stick to Massachusetts court law, not all the other states that also back this up. Now I'm saying, how can you change, this is going to be another question, how can you change natural rights? How can you redefine them? I have no problem with saying parents who create a child should have equal responsibility for it and equal rights to the child. But here we have a question of law. The common law defined it. One parent alone had a natural right to that child. As a matter of fact, in Whipple v. Dow, the husband died, and she had no rights to the child and no responsibilities for the child. That's how absolute that law was.
Mr. Cimini, here you filed a modification of custody and child support, correct?
Correct.
And what is the status of that in the Probate and Family Court?
The Probate and Family Court has decided there should be no change of custody. Things are fine just the way they are.
And is that final judgment entered?
That has been entered and appealed.
So you took an appeal from that?
Yes.
And that appeal is pending in the appeals court?
Oh, for months now, and I can't get any answer to tell me where the status is. It's not in the appeals court yet. It's still in the Probate and Family Court.
Have you raised these issues in the Probate and Family, in the appeal?
I raised these issues to the district court here in Boston. They said, you've got to go to Probate and Family Court.
You're talking about the federal district?
Yes,
court? Okay.
So I went to the federal court, didn't get answers there. I went to the appeals court on the jurisdiction issue because it was not answered. Okay.
The probate and family court.
On probate and family
The
court.
question is, did you raise them?
Yes, absolutely.
Have you filed your brief in the appeals court?
Yes, and I got back a handwritten, they sent it back to me. Handwritten on the thing was, we do not have common law jurisdiction. Go see the Supreme Court.
Was that part of the appeal from the final judgment?
No, that was part of the appeal as to whether or not the question of jurisdiction
Okay.
to the probate and family court.
Have you filed a notice, have you taken an appeal from the judgment,
Yes, that is separate.
and have you filed a brief in that case?
No, I have not gotten anything back from the probate court indicating for instance, the appeal court,
That the record is
Right.
being assembled?
right, all that. None of that has happened.
I just want to be sure that you understand just the import of Justice Glaney's question, that the fact that you have raised it in the appeals court once before does not mean that it should not be raised again.
I plan on raising it again in that appeals court. But I'm hoping this court answers the question.
Okay.
Because once a court's jurisdiction is challenged, it's supposed to be answered and not ignored. And these are serious constitutional issues.
The question is they can be answered. The question is when they are answered.
Well, he answered them well before the final findings and facts, and that's when I started going through the appeal process, questioning his final judgment regarding the jurisdiction. Okay?
Have you ever thought of engaging a lawyer to help you with this?
You're stealing money from me, and I have a family with another daughter. I can't afford to go and do this. Mm-hmm. So I have taken it on myself to do this. Now, I have my son from that marriage half-time, but I'm still paying a ton of money. And I'm saying that one of the reasons here in the findings is because the court is so interested in Title V money, Title 4D money, that I'm not going to get a fair hearing. My son stood up in court in front of Judge Donnelly, 14 years old, said, I want to be with my dad. And that didn't matter to the judge. Under common law, that would have mattered. A 13-year-old could have stood up and said that. And as long as the guardian would have been considered fit by the court would have honored that. Okay?
Mr. Cimini,
I would like to
I just want you
continue
to
with my
understand, we don't issue a decision immediately.
I understand.
And so if the record is appealed, if the record is assembled in the probate and family court, make sure you raise every claim that you have.
I already plan to. I've already
Okay.
practically written that thing. And I can't get the probate and family court to give me any indication of when that record is going to be assembled. So I just went orange, so let's go with the last 2 points. I claim that there's been invidious gender discrimination from the common law definition of who had a natural right to today. When you implemented the tender years doctrine, it was not about judicial discretion. Read that in the case that I just cited as slightly mistyping. Merson v. Berry, 25-164. It was a new natural right, a new interpretation of the laws of nature. It's an 18-page dissertation on the common law rights versus this new tender-year interpretation of the natural rights. Okay? Which then Judge Betts in the federal court said, we don't have common law jurisdiction. Because these things have to be decided under common law jurisdiction. The U.S. Supreme Court twice agreed with that. The first federal district agreed with that. And then the U.S. Supreme Court has stated that matters which were done at law, even though there was no right to a trial by jury, for instance, a trial by jury in actions unheard at common law, provided that the action involves rights and remedies, the sort traditionally enforced in actions at law, rather than actions in equity or admiralty, still have the right to a trial by jury. And I'm saying, in order to be fair and impartial, I should have a trial by jury to get rid of the question of the Title 4D monies that are being pumped into the courts. And I say that the invidious gender discrimination has been the father had the right. Okay, almost 100% of the time he'd get custody unless he abandoned him. Okay, tender years only targeted married fathers. Tender years was never, ever used in unmarried couples dispute of custody. Never. I can't find a case not just Massachusetts, anywhere. So you specifically targeted one gender. And then, with your 1989 statistics, taking the raw data and taking Dr. McNabb's data, which I also cite, it now says that the state is more likely to get custody than the father. So you went from almost 100% custody to the state's more likely to get custody. And Dr. McNabb's study, I believe, was about 1.5%.
It's a long road when you're on your own, and it hurts when they tear